Namaskara and welcome to BIC Talks, a podcast brought to you by Bangalore International Centre, where we present conversations that move, inform, and encourage discourse.
It's a fascinating development in administrative law. The very first case in which the Supreme Court was confronted with one of the most beautiful propositions of Article 21, they failed. This is Fazlali's dissent. A great judge, Mukherjee, was persuaded to sign on to the majority view. And no person shall be deprived of life and liberty otherwise than in accordance with procedure established by law. That expression degenerated into procedure prescribed by the legislature. So between law and procedure prescribed by the legislature and law enacted by the legislature, that subtle distinction, the values implicit in that, was lost sight of. It took almost 27 years for us to, though in between some noises were made by the Supreme Court. In fact, the Supreme Court had three phases of its evolution. It's a precedent-ridden court for the first 20 years. Beautiful judgments, but all precedent-ridden, overridden by precedent. Then they developed some new tools for legal control of government. That concept arose in the second phase. Third phase, they get into trouble with implementing those tools. How these tools conflicted with the established principles of known limits of court jurisdiction, how to trespass that. That was the third phase. That's the most fascinating phase in the development of law.
Welcome to None Wiser Than the Law, a series of conversations with Justice MN Venkatachaliah covering the law, his life, politics, and the Constitution. The title of this podcast comes from Aristotle, who said, "To seek to be wiser than the law is the very thing which is by good laws forbidden." The role of a judge is therefore not to presume wisdom, but to unearth the wisdom of the law. Justice Venkatachaliah quotes this aphorism in a judgment, and in this series, we explore his judicial philosophy that shaped India's jurisprudence. My name is Alok Prasanna Kumar, and I'm a co-founder of the Vidhi Centre for Legal Policy. I had a chance to speak to former Chief Justice of India, MN Venkatachaliah, in August 2023. In our conversation, we covered a range of topics, from his beginnings as a lawyer to his tenure as a Supreme Court judge, his landmark judgments, and his views on developments in law and society. In this episode, Justice Venkatachaliah spoke to us about his early life and career as a lawyer in Bengaluru. We asked him about his memories of Bengaluru at the turn of independence, influences in his life, and what the bar and the bench in Bengaluru was like.
It's a mixed feeling. It was quite a bit of a close family, a bar association, lawyer group of lawyers, and just then the constitutional aspirations had unfolded. There were no clear demarcations in their minds about the distinction between a private law and public law regimes in legal administration. It's a very interesting phase in India's history. There are great hopes, and at the same time, amidst great expectations, we had some kind of a glimmering hope that India was unfolding itself into a future beautiful civilization with great values of culture the whole world will share with. And the legal profession was limited. In the sense, it used to be said that the whole British legal system was dominated by forms of action. Once somebody said, "We have buried the forms of action, but they rule us from their graves." So you had to put your claim into a form of action. And that's the kind of limitation on the scope of judicial relief. That is the kind of thing. Whole cases could be classified into 12 categories. And we are familiar with the basic rules of the game in each of them, and you had the whole legal repertoire with you. And that expanded. That's a phase of great expectations. Great expectations of a great future civilization India could participate in. And law, as I told you, is a slow process. And that inheritance we have not been able to shake off even now.
I thought we could start the conversation, sir, with your memories of being a lawyer in the old Mysore state. You would have started practice just after independence, when it was still the old Mysore state. Karnataka, as we know it, didn't exist. What was it like to be a young lawyer in the 1950s in the state of Mysore?
I first went to the first Municipal Court, and the court hall could contain about capacity for 20 persons, had about 100 persons in it. And the gush of the smell of sweat and perhaps tears would confront you. And the presiding judge marked me out because he knew my father. My father taught for a generation of law students. He was the first principal of the government law college. He threw up a huge practice just for the sake of attraction of a teacher's profession. And out of turn, the very first appearance, he was hearing a case after the crowd melted out after the first hearing, as we call it. I was seated in the courtroom, perspiring, the kind of thinking what kind of future I can make out of this situation. He asked me a question about the case that was being argued. That's how a very interesting interaction started in my case. And of course, I dealt with a number of very interesting cases. And that's a stage where awareness of public law litigation was just unfolding. And there are some good lawyers who are more celebrated than knowledgeable. And some of them are very knowledgeable but not celebrated. It was a very interesting phase of the opening up of the new system which we now bear witness to.
So who would you say were the good lawyers? And you made a distinction. So let me go further on that. Who would you say were the good lawyers and who were the knowledgeable lawyers?
Very senior lawyer. Of course, I won't mention my own father's name because I'll be partial. But MP Somshekhar Rao was a very good lawyer. There was one Somnath Iyer was a good lawyer. There was Midlay Lakshmanappa had a stint as Advocate General, was a good lawyer. And Ganesh Rao was a good lawyer. S.D. Ganesh Rao was a good lawyer, very persuasive lawyer. His grandson, Naganand, is his grandfather. We knew them all personally. They were one thing was they were very, very friendly and helpful seniors. A number of them. And there's a good cross-examiner by Kanak Sabhapati. He was a very searing tool of cross-examination in court. Witnesses were afraid of facing him. And very few lawyers, almost only about 5 or 10 lawyers would come in automobiles of their own. All of them would come in pony carts. That's the favorite mode of transport in those days.
And those days, the municipal courts were located in which part of?
Just opposite the Manapa Park. That's called where presently the civil court complex is built.
Okay.
Old buildings are all gone and.
So it's the same place where now the city civil court complex in Bangalore is. It's just the older version of those.
And the cantonment courts were a little more fashionable. They were not very different in quality.
And this was the Mayo Hall area, right? The Mayo Hall court, right? I mean, those courts are still as they are. And, you painted a very interesting picture of sitting in a small room which could barely fit 20 people and sweating. And I think back to my experience of litigation, and that sounds very similar. So clearly that part hasn't changed. But how did your practice develop? What areas did
I inherited a great practice. My father was a very good lawyer, academically absolutely first class. He started his career as a teacher of philosophy in Maharaj's College. And one of the letters that the Vice Chancellor wrote to my grandfather, his father, asking his permission to allow my father to go to the West and come back to teach philosophy. That letter was exhibited by the Postal Department in their exhibition. In 1917 letter, asking my paternal grandfather to permit my father to go to the West because it involved the braving of so much of social opposition. And he didn't give permission. Then he resigned from his tutorship in the Maharaja's College, He was married into my maternal grandfather's family. My mother was the daughter of a High Court judge, and that judge persuaded him to go for law. He went to Madras and studied law, came back. He spoke English and law beautifully. And he threw up a huge practice to accept the principalship of the government law college. He started that.
And what made him, or did he ever tell you why he wanted to give up the practice to, teach?
See, he always longed for the life of a teacher. I suspect that his first love was teaching. He was a philosophy student. Just now I found an article written by him in the Philosophy Congress, a speech in the Philosophy Congress of 1956 in Srinagar, Law and Ethics. And it's a beautiful article.
Oh, wow. Okay. No, that's fantastic. And what were the specific areas? I mean, you mentioned law and ethics is the article that he wrote, but what were his areas of interest as a law teacher?
The answer I would give in a humorous episode in the Madras High Court. Before an English judge, a lawyer was asking, the lawyer was asked to say in a partition, what does the son take, what does the daughter take, what does the son-in-law take? He said, the daughter says this share, the son takes this share, son-in-law takes whatever he can lay hands upon. So the range of variety of litigation was so limited that usually partition suits for partition, suits for declaration of title, suit for injunctions, suit on accounts, suit for dissolution of partnership. They're all set forms of action. That litigation has virtually evaporated now.
It's true. And what sort of interests when I read some of the older cases is that this, at least in Bangalore, this whole idea of a writ petition was a very new thing. I know in Bombay, in Calcutta and Madras, they had a limited jurisdiction to issue writs. But in Karnataka, after the constitution came into force, how did lawyers and judges make sense of their new jurisdiction and powers?
See, Champakam Dorarajan's case was the beginning in Madras. And the nicer distinction between private law and public law slowly emerged, though they were not very clear. In England, the procedure was prescribed for public law and private law litigations. The rules demarcated the two areas exclusively. Here, it's a fascinating development in administrative law. The very first case in which the Supreme Court was confronted with one of the most beautiful propositions of Article 21, they failed. His first Lali's dissent. A great judge, Mukherjee, was persuaded to sign on to the majority view. And no person shall be deprived of life and liberty otherwise than in accordance with procedure established by law. That expression degenerated into procedure prescribed by the legislature. So between law and procedure prescribed by the legislature and law enacted by the legislature, that subtle distinction, the values implicit in that was lost sight of. It took almost 27 years for us to, though in between some noises were made by the Supreme Court. In fact, the Supreme Court had three phases of its evolution. It's a precedent-ridden court for the first 20 years. Beautiful judgments, but all precedent-ridden, overridden by precedent. Then they developed some new tools for legal control of government. That concept arose in the second phase. Third phase, they get into trouble with implementing those tools. How these tools conflicted with the established principles of known limits of court jurisdiction, how to trespass that. That was the third phase. That's the most fascinating phase in the development of law.
And this is what makes me think, did people, because Mysore state was never formally part of the British Empire, in India at least, and people had a very different relationship with the government from what I understand. How did people react to government decisions? Because today instantly everybody thinks if you're unhappy.
My impression is this, it's a beautiful question. How did people themselves respond to their new rights, new awareness of their fascinating expanse of their own personalities in participation? That didn't happen because I suspect a regime of kingship, people they were subjects, not citizens. That kind of overhanging awareness of limitations of their own personalities was, but though it must be said that the most enlightened of all the kingships in India was exemplified by the Maharajas of Mysore. But still, there is a distinction between a citizen and a subject.
Now that's a huge distinction, because I think overnight the subjects became formal citizens.
Yes, that's exactly. That transformation took time to be absorbed.
The legal change still needed that social or the mental change for people to make.
Civilization changes. It's
Yes,
not
a civilization change, absolutely. We still think of it as legal change. No, that's a very important point, because to me, what I sort of want to understand is you had a career of about 20 years or so as a lawyer before you were elevated as a judge. How did you see the practice of law change during the time in the 50s, 60s, and the 70s?
This was a little slow, but surely the change was perceptible. People walked with straighter backs, with a sense of anticipation of something good happening to them in court. The second thing is it enormously enhanced people's faith in courts and their powers. That's again a civilizational change. And courts did not perhaps rise up their expectations, and that is again a kind of a depressing factor. This history of this is a fascinating study. How people's expectations rose, the profession, how disillusionment, cynicism comes up when your expectations are high, and when you don't reach those levels of achievement, intellectual civilization achievement, then there is a disappointment, disillusionment. Disillusionment produces cynicism. Cynicism is a power of destruction, it's not a power of reconstruction. We say that it's being played out now today in this thing. It's all, when you trace that, it is somewhere, sometime, somehow, something inside, you suffer a disillusionment. Disillusionment of leadership, disillusionment of systems, disillusionment of personalities, disillusionment with religion, disillusionment with God. All this kind of thing produces a sense of cynicism. It's a tool of destruction.
So let's start with that initial phase of hope, that initial phase that people believed in the courts. What were the kinds of cases? Do you have an example of how somebody approached you, perhaps, with an expectation from the court, and how did it pan out?
Right. Somebody came to me for a petition against service in the life insurance corporation. The judge promptly said, this is a corporation, not state. It required Ramana case to come up or other cases to pave the way. We took such narrow view of state Article 12. What's an authority? In fact, in Supreme Court, some of the observations in Supreme Court would call out negative things. The purpose of creating corporations by states was to keep them outside legal control of government. It becomes judicial control of government. And in that distinction, we should very carefully watch. How is the development? How, of course, this is we go to Cardozo homes. My goodness, what kind of fascinating developments it occurred. The second phase was led by, the charge was led by judges like Bhagwati, Krishna.
And it is very interesting to me that since you mentioned Mr. Krishnaiyer and Mr. Ramjit Madani.
The transformation of legal phraseology and legal vocabulary has a message. It is itself a response to the conscious awareness of the limitations. In fact, language has been a great limitation on law. Many authors have said that, Justice Denning once said, with one or two words you can destroy your client's case in court. And how language is limited, and the legal vocabulary doesn't exceed 300 words. You have to play within that. And words become limitation on ideas, vice versa.
To go back to the time when you were practicing, who were the kinds of judges whom you saw, and how did they kind of inspire you in this particular, in the Karnataka High Court specifically, and so on?
They are much bitter and fossilized kind of presentation. And some of them were good judges, but the area of their operation, scope for display of judicial intervention, display of judicial creativity was very limited. And the tyranny of precedents limited their scope. And all that you need to do is to cite a couple of binding precedents, the matter was over. And this kind of subtlety was supposed to be the besetting sin of the legal mind. But that was absent in that kind of limited kind of thing.
And did they appreciate innovative arguments, new approaches to interpretations?
They appreciated, but they were willing to wound, but afraid to strike.
I don't know if it is a mindset about, say, those who practiced law during the British era or those who started post-British era, because we see that change in the Supreme Court also, like you mentioned. Who would you say was the judge in the Karnataka High Court who did something like perhaps what maybe Justice Chandrachud Bhagwati and Justice Krishna did, who brought a new, fresh approach to the...
They were traditional judges. Their division, but pursued the system as a limitation on innovation. They thought their instinct for innovation was limited by their apprehension of the limitations of the judicial role. In private conversation, we could see that's exactly where I lament. There's not much of legal theory translating into action in courts.
In that sense, how do you imagine legal theory could have translated into action? I mean, if we had to take an example.
See, Nakara case, you would say, in the Supreme Court. Ramana case. There's a famous case in Kerala in 1969. One and Thomas was the state of Kerala. 3-judge bench. Justice Matthew was one of the members. P.T. Raman Nair, Chief Justice, was there. And another judge who later came to Supreme Court of the bench. By majority, they said, but blacklisting, there's no need to ask for a show cause. In a beautiful dissent, Matthew said, elicited the principles of public law and told the brother judges, my friends, you are asking me the hour of the night, it's already morning.
That's very interesting. That's a very evocative way to put it. And now, of course, the law is that even for blacklisting, principles of natural justice will have to apply. And just for this thing also, in those days, did senior counsels and advocates from other states come to Bangalore to practice? Did they practice before the Karnataka High Court?
No, very few people would come. I think A.K. Sen appeared before me in a number of cases. And there's one, Chitale, Dr. Chitale, a very fine lawyer. He used to come to Bangalore.
From Nagpur, right? A.V. Chitale.
Chitale, he was practicing in Delhi.
Oh, okay, he was in Delhi.
He was the son-in-law of Bharadwaj, not Bharadwaj, that famous Indira Gandhi's lawman who resigned from Bombay High Court.
Gokhale?
Gokhale,
yes.
son-in-law.
Yes.
I think Chitale's daughter was Chandrachud's first wife, the present Chief Justice. That girl, a nice girl, she died of... I knew that family, Chitale's.
And what about other lawyers who would appear in the Karnataka High Court?
They are very good lawyers. Some youngsters were very good. M.K. Viswanathan, who is now a Supreme Court judge.
Oh, K.V.
Viswanathan. He was just a junior in my court. And he used to have a very pleasant time.
Okay. But I suppose mostly only Bangalore lawyers would still appear in Karnataka High Court.
And one Kinney used to come from Bangalore. And one P.S. Rao, a very fine lawyer from Bangalore, once very occasionally would come. And whenever he came, he assisted the local lawyer.
Okay.
And everybody had great respect for him.
We could discuss who were the lawyers who appeared before you, your colleagues and judges, just your impressions of them, your experiences with them, some of the names mostly. So this is just to sort of get a sense of what it was like, the bench and the bar in those days.
He was the Advocate General of Midley Lakshmi Narayanappa. Then MP Somashekar Rao was a senior lawyer and he was a respected lawyer. There's one, M.R. Janardhanam was a trial lawyer. He had a large practice on the trial side. M.R. Janardhanam. You used to call him Dhanardhanam.
Why would you call him Dhanardhanam?
Dhanardhanam is earning money.
Okay.
Janardhanam used to be called Dhanardhanam because of his known prosperity in the profession. Then there was the famous S.K. Venkatachaliah, who used to be called the Writ Iyengar because he first started filing writ petitions in admission cases.
This name I have heard even from my parents, who are not lawyers or anyone, but he was so famous, even non-lawyers knew the name of a Writ Iyengar.
Writ Iyengar, he was called the Writ Iyengar. Then there is S.T. Ganesh Rao, Naganand's grandfather. And then there's one trial lawyer by name K.N. Srinivasan. Then there used to be another trial lawyer, a good lawyer by name Kanaka Sabhapati, with a good cross-examiner. Then there is a Mr. B.V. Ramarao, M.N. Srinivasan, who wrote a book on Hindu law. Then there's another lawyer who came from a well-to family, Putsidaya. He was very well-dressed and very elegant and known for his sartorial excellence. Then Hethrachul Naidu, who later became Advocate General, he was a very fine, good lawyer, both on the civil and the criminal side. And he was editing a paper also in those days. Then Mir Iqbal Hussain was a leading lawyer and he became judge later, Mir Iqbal Hussain. Then Nittur Srinivas Rao, his colleague Gopi Vallabhai Iyengar, his son K.G. Raghavan is a leading lawyer here. I'm speaking of before the integration of Madras and Bombay provinces into Karnataka, before 1956. All these names I mentioned. Later on, hordes of lawyers came from Tamil Nadu, Andhra Pradesh, Hyderabad, Karnataka area, Bombay, Karnataka area, and the whole scenario changed so vastly. Then, in the cantonment bar was distinct in those days. They had their own association. And Mr. Xavier was the senior lawyer there. Then there was one DeCosta, and there was one S.V. Subramaniam. He spoke well. His diction in law and language was quite distinct from the ordinary rough and tumble of the courtroom. And there's one very impressive gentleman, Bhajakal Shankar Rao, who was a huge man. He had a very patronizing attitude towards everybody. And then the judges, there were only 5 judges then. Originally 3 and then became 5. Made up of the Chief Justice.
In the next episode, we hear from Justice Venkatachaliah on his tenure as a judge, both in the Karnataka High Court and the Supreme Court of India, and his post-judicial career. This episode was recorded at the Indian Institute of World Culture in Bengaluru, and I'd like to thank the team and staff at IIWC for making this possible. I'd also like to thank my colleague at Vidhi Bengaluru, Pratiksha Ulal, for her research help during this podcast.
You have been listening to BIC Talks by Bangalore International Centre. If you like what you heard, do follow us on social media. Keep up with our programming by signing up for our mailer on the website or leave us a review or rating on Apple Podcasts or iTunes. The crew that makes these podcasts possible is Gaurav Krishna and Ishan Gupta on sound supervision and production, with support from S. Sarunaraj and Raghu Tenkaila. Artwork is designed by Chandni Venkataraman of Crisscross Design Studio. Don't forget to subscribe to our channel on your favorite podcast platform. It can also be accessed on our website, bangaloreinternationalcentre.org. This is Lekha Naidu signing off on behalf of everyone at BIC.